How do you get 6 months imprisonment for shoplifting a bottle of water? Let's find out. Welcome back to Black Belt Secrets, and we welcome back our learned Alan Roberts Shaw. How are you doing today, Al?
I'm doing very well, thank you, and it's very nice to be back on the channel with you.
Pleasure to have you back. Today we're going to talk about the Public Order Act, because if you haven't noticed, there's some unrest around the UK, with some people even calling it the beginnings of a civil war of sorts, but certainly civil unrest. We're going to talk a little bit about, well, Al's going to mostly talk about the Public Order Act and sentencing guidelines and what people might be sentenced to, because there's also talk about these 24-hour courts to try to rush everybody through. Have you heard about that as well, Al?
I have. We've just been commenting about it because back in 2011, they tried a similar idea to sort of rush through the justice system. My view is it just will not work. The logistics are just not in place. I mean, we can barely operate an 8-hour court system at the moment. So this is complete flannel, to be perfectly honest.
Indeed. And I've lost track of how many times I've had something that's listed at 10, because a lot of people probably don't know this, but most cases are listed at 10 o'clock. And that's just because they've got no idea, or they can't be bothered to figure out exactly when it's going to be heard. So they list everything at 10. Everyone's supposed to turn up at 10. And then you get on, as in you get into court, whenever you get into court. So I've left the house before now at like 5 o'clock, got there for 7 or 8 o'clock, ready to meet the client at 9 o'clock, listed at 10 o'clock, and I've got into court at like 5 to 4, by which point the bench has left, and they said, well, we can't do anything but directions anyway. I was like, well, that was a waste of time, wasn't it? But anyway, we won't criticize the courts too much, but it's not that efficient. But nonetheless, they're expecting, the reason for all that is they're expecting to have a lot of people go through and try to prosecute people for public order offences. So we'll bring in the Public Order Act 1986 and what might amount to rioting, which has all sorts of implications, and what people might get. So where do you want to start, Al? We've got different sorts of public order: affray, riot, violent disorder. Let's start with affray.
Because all these three offences, they have similar elements, which is engaging in behaviour that put a person of a reasonable firmness in apprehension of the imminent use of violence. So effectively, that is, your behaviour is such that, somebody who's not too timorous, as they say, but also not too sort of gung-ho, would be thinking, hang on, something's about to kick off here. Now, it doesn't actually matter particularly if the person, actually watching was going, bring it on, all for it, because it's this hypothetical person of reasonable firmness. And such a person doesn't actually have to be present. It's a purely objective test. But the difference between affray is something you can commit on your own. Violent disorder is where three people engage in either violent behaviour or giving the threat of the imminent use of violent behaviour. They don't actually have to be acting simultaneously or in collaboration, but there's this idea of acting in concert, because it's obviously a lot of these things aren't planned. I mean, to speak about my recent video on conspiracy, this isn't even a nod and a wink thing. If you happen to be independently scrapping in one corner of the street and two other guys are scrapping in another corner, that could be enough for violent disorder. And if there are 12 or more of you, that turns it into a riot, which is a very, very serious offence.
Indeed. And they each attract their own sentences under the sentencing guidelines. And you were saying earlier, Al, before we hit record, that, and indeed formed the intro for this video, is that just an offence forming part of or committed during a riot or violent disorder exacerbates the offence itself, which leads to a higher sentence just because whatever it is you've done has been during this disorder or riot.
Absolutely, yeah. So even if you are not, even if you are not convicted of riot or violent disorder, you just commit another offence while a riot is going on. You might be going, nothing to do with me, but I'm going to take advantage of the fact that the police are all very busy. And in that particular case, this was in 2011, some young lad just shoplifted a bottle of water. He was duly caught and convicted, but because it was during a riot, he got 6 months immediate custody, whereas normally, I mean, you'd be, that probably possibly wouldn't have even made it all the way to court. But the idea is, look, the police and the authorities have enough on while all this is going on. You are not helping the situation by taking advantage. Another thing that I think a lot of people are going to find is going to sort of bite them in the backside, as it were. If you live in social housing and you are convicted of an indictable offence, that's like a not summary offence, so not sort of something that can only be dealt with in the magistrate's court, like a traffic offence, you can be evicted. And if you are the leaseholder, your entire family can be evicted with you. So if it's just a member of your family is convicted of an offence during a riot, then you've got a choice. You either say, right, we need you to move out so we can stay here. But if their name is on the tenancy, then you lose the tenancy. That was brought in after the previous riots. I mean, there is an argument that that's effectively collective punishment because your entire family can get evicted because of what you did. But that is on the statute books and they do enforce that. So it'll be interesting to see, if people are convicted of offences. And like I say, you don't have to be convicted of riot or anything. You just have to be convicted of an offence that occurred during a riot. I mean, obviously, if you are convicted of riot, it also applies because by definition, that is an offence that occurred during a riot. So yeah, the penalties are really draconian. I mean, in the 2011 riots, I did have a look at this. About just over 5,000 people were convicted through the courts, and the sentences went up to 4 years for people, which actually, I suppose, when the maximum sentence is 10 years, arguably that's, not too much. But they really threw the book at people. I mean, people were getting immediate custodial sentences for offences that would possibly have been dealt with if it was just you, having a pub fight, you'd probably be looking at community service or a bit of probation, but people were going away for 4 years.
Indeed. And just talking about immediate custodial sentences, there's pressure. I mean, we talked about the pressures on the courts for the 24-hour courts. There's pressure on the prison systems, and there's been lots of talk of releasing people to free up space in prisons. This is obviously going to make things a lot worse if there's hundreds or thousands committed immediate custodial sentences from what's going on. And this is just in a couple of days. There must be hundreds and hundreds already. I mean, just from the very few videos, I haven't taken too much attention to it. I've been trying to live my life, but just the few things that I've seen, that you can watch for 5 seconds and see a dozen offences by a dozen people, all of which would meet the requirements here for immediate custodial sentence if it's deemed a riot. And another interesting, you mentioned losing the tenancy as social tenants and things like that. There's other things where insurance companies have either limited or excluded damage from anything to do with riot and so on. I was reading one just the other day where an insurance company had excluded such things, and it's therefore down to others to pick up the tab for such things. So the only thing we can say there is look into your insurance policy, like quick, because obviously if this is going on now, it's good to know whether that's covered or not. But then we've got the sentencing guidelines, and as you say, riot is a maximum of 10 years with an offence range. Now, there's a few things here with the range, and a lot of people get confused by this because most people don't understand the range versus the maximum and how you end up at what this is. So very broadly speaking, we've got in most sentencing guidelines culpability and harm. Now, these are just guidelines, but they are guidelines that the judges are supposed to follow and only come outside of it when there's good reason, and ultimately it's down to the judge to pass sentence. But culpability and harm, how much are they held responsible and what is it that they've done? So typically things like whether there's serious planning involved, or whether they've deliberately targeted someone who is vulnerable, or they've used particularly dangerous weapons or dangerous planning and actions and things like that. And then levels of harm, how much harm has it caused to somebody, how long for, and what effect would it have on them for the rest of their lives. Now, an interesting one here is this is highly dangerous weapon bit, because this comes into play with the use of vehicles, because I say that because I've seen one video with the use of a vehicle. Now, some people were attacking the vehicle and the vehicle was attacking the people. So arguably they are both guilty of offences there. And if a person in a vehicle is driving at somebody else, a vehicle is a highly dangerous weapon. And so,
Well, yes, I mean,
yeah.
Sorry.
Go ahead.
I mean, obviously, just to plug, before we get too much into sentencing guidelines,
Absolutely.
somebody did a video recently all about how sentencing guidelines work and the Sentencing Council, and how the sentencing by spreadsheet formula does work. But yeah, I mean, this is the thing. Riot and public order offences is something where the Sentencing Council have given guidance. Now, just to go back to your thing about attacking the car and the car attacking the people.
Yeah, just before you do that, Al, people can find your videos and your channel over here on Art of Law. It will be linked in the description below. Make sure you go and check it out. You get some much better scenery than you do on my videos as well. So do go check that out and find that video there. But you were going to say before we talk about the vehicle.
Yeah, well, actually, speaking of vehicles, I took out one of my tyres because to get to Cambrai, where I was yesterday, you have to drive up a flint track. And my tyre had a bit of a row with a piece of flint stuck in the side of the track and lost quite considerably. so my poor Truckosaurus needs new tyres. I've actually just got back to fit them tomorrow. Climbing my scruff because I've been changing tyres. But this is an interesting thing. You were saying about the vehicle attacking the people attacking the vehicle. Let's say you've got 6 people on each side of something. Say it's that they're antagonistically opposed to each other. So it's a protest and a counter protest, and it all kicks off. The irony is that you are then acting in concert, and there's the 12 people. Now you can argue and say, well, we weren't acting in a common aim. We had completely different goals. We were enemies, but it's like, well, no, it's deemed that you are acting in concert. So there's the irony that getting into a punch-up with your rivals can sometimes make it a riot, because the court is not interested in why you were doing it or what your cause was, or if you're the good guys or the bad guys. Quote. The argument is, well, no, you've taken it too far now. And, this person of hypothetical reasonable firmness walking past, if they sort of go, they're not going to go, whose side am I on looking over there? They're just going to go, wow, am I at risk here? Because the idea is, does something spill over? I mean, I've defended a phrase in the past where, although technically the elements of the affray was met, it was clear that this was just guys kicking off, in a pub car park. And you could just stand there and watch and you weren't in any danger. And the argument was, well, the offence is that it's a public order offence. It disturbs the public and puts the public at risk. This clearly didn't, nowadays, people would have stood around filming it on their mobile phones. I do remember one judge, actually, because this is the thing. It was actually in this case because he was having to go at the prosecution as to why they prosecuted it as an affray rather than just, like an assault or something. And he said, in my day, people lost limbs in affrays. It comes from the Norman French, affray, to terrify, and just went off on how this was been completely overcharged. But when they do charge these public order offences, because, they attract very, very severe penalties. I mean, like I say, I was looking back to the 2011 things. Now, interestingly, some of these people might be very shocked as to how fast this can act, even without, forget the 24-hour court nonsense, because that's just not going to happen. We've tried this before several times, and we've had like 3 cases, and then it's all fallen because the jailer, the security people couldn't get people to the court on time. They couldn't get the paperwork there. The fax machine wasn't working, showing my age. But if you are arrested for one of these offences, you will be taken to a police station and charged. You will probably be held in custody because then they will produce you at the next available magistrates court date, which can include magistrates courts sit on a Saturday. So you'll be there the next day, even if it's a Saturday. If you're arrested on a Saturday after 4:00, then you're going to be sitting there till Monday. The magistrates might say, well, this is far too serious for us to deal with. And the procedure now is you are just sent to the Crown Court. In the old days, we had committal hearings and all this sort of thing, and old-style committals and new-style committals. A certain age will be remembering that with fond nostalgia. But now the court just says, this is too serious for us to deal with. It goes to the Crown Court. And they have set it up so that they can be sent to the Crown Court that day. So you appear in the Magistrates' Court in the morning. You are then driven across town to the Crown Court for your first appearance. And if you say, well, actually, I'm going to have to, you're advised you've got to plead guilty to this. And the earlier you plead, the bigger the discount you get on the sentence. If you plead at the earliest opportunity, you get 1/3 off the sentence. You could be sent to prison for, like I say, 4 or 5 years there and then. So I think a lot of people are going to be shocked as to, even without the 24-hour court thing, as to how quickly a little bit of idiocy suddenly amounts to a 5-year sentence.
And sends them to prison, exactly. And just to give some context with the whole public order thing, I have a very real story about this, because I'd been across the country somewhere to some sort of stag party, and we were headed toward a certain pub, and out of which spilled 1 or 2 guys, and we sort of stopped and observed for a minute and said, oh, hang on a minute, just, well, everyone else was, no, let's go, it's fine. And me being the sort of ever cautious, somewhat paranoid person that I am, I was like, no, just stand and watch for a minute. This doesn't feel right. And this is what you said, Al. Does a person of a reasonable firmness sense that they might be at risk of some kind of immediate harm here? And so I looked across the road and I said to the few of us that there were, I said, just hang on a minute. Let's observe what's going on, because that's where we were going. And there's 1 or 2 guys came out having a bit of an argy-bargy. And sure enough, not 2 or 3 minutes later, it went from a bit of disquiet and 2 guys having an argument to there were police helicopters, riot vans, bottles being hurled across, and all hell broke loose. By which point we'd obviously started making our way away. And that's the difference between walking down the road and seeing a couple of guys, I use the term generically, having a bit of an argument, to this is really a danger to everybody just in the local vicinity. And so that for me was really telling. It's the first time I'd really sort of been stopped in my tracks to think this is about to kick off. And it was only just because these 2 guys came out, and they weren't physically confrontational at that point. They were just shouting at each other, but it was indicative of what was going on inside. And then, of course, more and more people spilled out. And obviously the police had got wind of this somehow, probably by the landlord of the pub. And then the helicopters came, riot vans, everything, and it all kicked off. And then coming back to your point about riot here, it's the wording of it that really counts. It just says where 12 or more who are present together, it doesn't say whose side they're on, use or threaten unlawful, for a common purpose. Now, the common purpose might be against each other, but it is still a common purpose, isn't it? Taken together such that would cause a person of reasonable firmness present at the scene fear of personal safety. That's exactly what I was talking about. So that, for all purposes, was a riot, because there must have been at least 50 or 60 that spilled out of that pub. And it caused us to think, crikey, we better move, because we don't want to get involved in this.
Well, yeah, because the common purpose is the disorder. Because otherwise, you'd always be able to defend yourself in a riot, especially if it's like a, knowing a lot of like left. Well, of course we're not on common. We can't agree on anything. We couldn't. We don't act in common purpose. I'm an anarcho-syndicalist, and they're a sort of anarcho-cap. It would get very confusing. Now, of course, Dan, you see, you not being a person of reasonable firmness, you doing all the pole-arm stuff, you being a person of extreme firmness. But just to go on about riot, in the old days, we had the Riot Act, where they would read the Riot Act to you. And one of my favourite pubs, which was featured in quite a few of my videos, and where I quite often do a lot of my editing, so I'll say hello to Beowulf in Falmouth, that was the first place in the UK where the Riot Act was actually read. And just to give what that was, that used to be the headquarters of what they call the packet ships, which were like the mail ships, basically the delivery guys back in the day. But they also had a little sideline in they would assist customs and excise in confiscating, smuggled goods. But there was also a little deal, which was they were allowed to take a taste of it. It was like, we've helped you seize all this tobacco or this rum. And there's actually a chimney stack on the quayside. Next time I go down to Falmouth to do my Dudley and Stevens video, I'm going to actually film it because that's where the cannibals landed. But that would all the tobacco and contraband would go to be burnt. But the idea was they gave some of it to the guys on the packet ships, and then they said, "Well, actually, no, because this is meant to be illegal stuff. You can't just take it." And because they said, "Well, hang on, we hardly get paid anything here. This is our bonus." And they stormed up to what is now Beowulf on the steps, and they came out because the Riot Act was relatively recent, and they read the Riot Act to them and said, if you do not disperse within 1 hour, it's going to get fairly messy. And actually, they did disperse, but then they went across to another pub, which is now the Seven Stars in Flushing across the river. I should do like a legal history of like legal stories, all based on pubs I like drinking in. But yeah, that was the first place they read the Riot Act. And I remember
Over on
seeing
Art of Law, so make sure you go and subscribe.
Yeah, absolutely. Please subscribe a lot. But I remember once in an army surplus store, they actually had one of the banners that they used to hold up. And they actually used this, I think they used this in India, but I think they had similar things they used in Ireland, where they would hold up a banner saying, you are now in breach of the Riot Act. If you do not disperse within 1 hour, we will open fire. And if you remember, actually, that after in India, with all the sort of like Gandhi stuff and India, there was an inquiry because they did open fire on a lot of people, and including women and children, and that actually sort of turned the tide of public opinion, and we don't have that anymore. Partly because of this idea that you can't just open fire on people just for standing there. Although it wouldn't surprise me. I mean, the idea of I'm going to, we still say it, don't we, as a say, I'm going to read you the Riot Act, or he read the Riot Act to me. And that's where it came from. They would give this declaration, and then you had 1 hour to disperse, or they could come in sort of like cracking skulls or opening fire. Obviously, we don't have that now, but we do have Section 14 dispersal orders, where they can come in and say, right, a police officer has to stand there and say, right, you must now disperse, and if you don't disperse, you commit an offence. But the officer actually has to be present at the scene, and they have to say it because they overturned quite a few convictions after some of the sort of Extinction Rebellion protests because they did it by tweet. They just sort of tweeted, "You've got to not be here anymore." And they say, "Well, hang on, what if you're not on Twitter?"
What if you're not on exactly.
And also, they have to do it in each area. And they said, well, effectively, they were trying to say it was anywhere that anybody was gathering, they had to leave. And the court said, well, no, you've got to specify an area. You can't just sort of imply it's all of London or it's the entire country because things were happening in different parts of the country. So now, all they have to do is literally just send somebody, it's got to be a particular rank as well. So you put an inspector on his bicycle and say, right, cycle down to Trafalgar Square or wherever it's kicking off, or Doncaster town centre. Not disparaging Doncaster there, I'm sure it's a very nice place. Well, it is a nice place, but a police officer has to say, okay, move. And if you don't move, then you commit an offence under Section 14 of the Public Order Act.
And that was a thing with the Tommy Robinson case as well, which I covered over on my quote-unquote main channel, where the police officer there had used a different order to disperse, but not the one for the area that it was in, and it was all very complicated. And so it turns out he hadn't really looked at it properly, hadn't really assessed it properly. It was just a generic, you've got to move, and therefore it was wrong. And the judge there felt that it was necessary to put all the reasons into the public domain. It's quite literally said the public have a right to know. And on the point of those dispersal orders, that even found its way now into the sentencing guidelines, because it says here, one of the aggravating factors, those of which make a possible sentence worse than it would be otherwise, commission of an offence whilst, where is it? It's refusal to, here we go, ignored warnings or exclusion notices. And so where an offender has had the benefit of warnings or advice about their conduct and failed to heed it, etc. So if they are told to move, or if they're banned from a certain area, or all those kind of things, those are aggravating features as well.
Yes.
And so those can all of which make this worse. And that's where we come back to the ranges here. So once we've looked at culpability, how involved were they? Were they part of the planning, or did they just happen to join in because they were walking past? Level of harm, did they just steal a bottle of water, or were they the person that put the brick through the window? And what harm did they cause with their offending? And then you look at all of the other factors here, and judge draws a conclusion as to where they sit on the range here. And the ranges are just typical ranges. And then obviously...
Also, you don't actually have to be present. So, sorry just to interrupt, but this is something when people are being inflammatory on social media. In 2011, a number of people got 4-year sentences just for going on Facebook going, yeah, let's get out there and let's do this. And the irony is, in some of the cases, nothing happened. Everybody ignored them, but they still received 4-year sentences. Now it's the Serious Crimes Act 2007. It's what we used to call incitement, but now we don't call it incitement. But if you do something that encourages somebody to commit an offence, then that is an offence in itself. And that can attract, because that basically attracts the same punishment as the offence you were trying to encourage. And like I say, so people were getting 4 years just for putting Facebook posts saying, hey, why don't you get down there and kick off? Even when nothing actually happened. So all these people tweeting away going, this is great, go on. So, they've got to be very, very careful, and the internet is forever. I mean, and also after 2011, even though they rushed a lot of people through and people were literally being sentenced to lengthy custodials within 24 and 48 hours, they spent months afterwards tracking down absolutely everybody. It's interesting that actually in the areas where they did this, riot-related crime really, really dropped. Public order offences really, really plummeted, but non-public order offences actually increased. And people are arguing about, well, is that just because the police resources were diverted? But they wanted to stamp down on this, and they threw absolutely every resource at it. And it wouldn't surprise me if that's something they do on this. So I would be saying to people, I don't give advice, obviously, but if you've put something on Twitter that is highly inflammatory or even possibly inflammatory, maybe it's time to start deleting it and perhaps trying to dilute the effect of it or something. Get your mitigation in early. Otherwise, you could well be going to prison just for a tweet.
Yeah, indeed. And it all comes down to what do we want and what would we accept in a civilized society. Now, there are obviously arguments, and people believe they have reasons on both sides of everything that's going on, but none of which will ever justify any kind of criminal act and rioting and so on. As we've said in previous videos, and I know you've certainly said in some of your videos, Al, over on Art of Law.
Art of Law.
There is nothing that will justify criminal acts when you're just going out with the intent of peaceful protest. And we've talked about the Just Stop Oil protests, but they went beyond just peaceful protest to serious disruption, and the courts have now said this is going to be treated accordingly because of the level of harm that it caused. And I thought that it was ironic that some of them are now sort of complaining about what they will miss because they've been given custodial sentences, which largely reflect the disruption that they caused to millions of other people.
Yeah, I mean, that's reflected both in public order. An aggravating feature is disruption to the public. I mean, it's strange. You could, you're all, if you were like a football hooligan and you just went off on a piece of wasteland somewhere and you had your big scrap, then you'll probably all get done for like a fray, because even though a fray can be committed by one person, it can be committed by multiple people. And they tended not to charge football hooliganism as riot. because it sort of failed, unless they were doing it in the town centre, then they'd do it as riot or violent disorder. But if people were sort of, as they used to do, by appointment on the local wasteland or the local rec, they say, well, actually, you are isolating yourselves from people who don't want to be involved, so it wouldn't be right to treat it as a public order affair, as a riot, because anybody walking past is going to go, "Ugh, look at those people." But unless you're wearing the appropriate shirt or scarf, do people still wear? In my day, people used to tie their scarf around their wrists, showing my age. But yeah, I mean, the whole point of public order offences is you are being penalised for the disruption and the fear you cause to the public, not each other. I mean, you can still be charged. You can be charged with riot and be charged with GBH, ABH, criminal damage, assaults, a whole host, theft, as we've seen. And even though we have this idea that you shouldn't overcharge people and you shouldn't duplicate offences, so it's like, well, actually, this person's done one thing, but there are 3 separate offences that cover it. Let's charge with all 3. What they tend to do with riot is say, we'll charge you for the general riot thing, but we'll also charge you with the actual individual offences you committed as part of that. So, you could get done for assault on a police officer and riot. You could get done for criminal damage if you smash a police car and riot. You could get done for theft because you looted the shop and riot.
Mm-hmm.
And while there is this idea of totality in sentencing, that the idea is that whatever sentence you get and however long you spend inside, it should reflect the overall totality of your sentencing. It can soon start adding up if you've committed multiple offences while you're out there.
Yeah, absolutely, and of course, previous history, previous convictions, otherwise previous good character, and so on will all come into consideration here. And it's interesting. With regard to football and everything else, they very often would just refer to it as a series of isolated criminal incidents around the area, and as you say, involving each other and not anybody else. But when it does become a generic impact on everybody else, then it's more likely to be considered as a riot. And so I thought that was very interesting, because this is now very topical. This is exactly what's going on in various places around the country. A lot of unrest, and a lot of people have a lot of questions, and hopefully that's a useful overview as to how this might be approached. Clearly, we don't think the 24-hour courts thing is going to work very well. I mean, we might be surprised it might work very well, but I doubt it.
I doubt it, yeah.
I think the courts and all of the resources are sort of stressed and pushed as it is with the backlogs and everything they've got at the moment. But any other closing thoughts, Al?
No, I just wanted to say how much easier this is to do when I'm doing it with you and we've actually got the relevant material in front of us, as opposed to my usual way. For anybody who's not seen Art of Law and is expecting it to be all slick and professional like Dan does it, let's just say it's a slightly different production style. It's basically me going somewhere and trying to remember something about a topical subject and definitely going, I'm sure there's something in the sentencing guidelines about this. I'm sure that, and people go, oh, I love the way that you just speak in layperson's language. And to be honest, most of the time is because I cannot remember actually what the elements of the offence are actually phrased as within the relevant legislation. So, it was a lot easier actually having the material in front of us. But yeah, I mean, I think we've covered everything. I mean, it'll be interesting to see how this plays out. But I think a lot of people are going to be very shocked as to what sentences are going to be handed out here. And even without all this idea of the 24-hour courts, which ain't going to happen, just the speed at which people are going to end up inside, but also just the tenacity that the authorities are going to use on this. They are going to chase after everybody, even if it takes months to find them. Yeah. And I suspect we're going to see a lot of prosecutions about posts on social media.
Yeah, oh, absolutely, indeed. I mean, if there's one message that is clear, is that the support for these prosecutions is going to be there. The support for the police is certainly there, and I think there's a lot of blame gaming going on, which I don't support, and quite clearly we don't support any of the criminal and violent acts that's going on. Whilst I think a lot of people do understand a lot of the reasoning behind it, it doesn't justify what's happened. And it's not the way to go about it. So there we are. I think it'll be, as you say, it'll be very interesting. There'll be a lot of prosecutions coming out of it, but we shall see. But hopefully that gives you a good idea of how to understand what is going to happen. So make sure you subscribe to Art of Law if you want more from Al with better scenery than you get just looking at me and my desk. But also make sure you subscribe here, my main channel. And we thank you all for watching. And Al and I will see you very soon. Take care.